rental fees, and we're going to call up Albert Sardinas, I believe is in person, Sarah Nagy, staff attorney for Columbia Legal Services, Scott Crane, and Terry Anderson. And Scott is with the Northwest Justice Project, and Terry is with the Spokane Director of Policy and Director for the Tenants Union of Washington State. And Terry's going to be virtual, I believe. There she is. Okay.
Hi.
All right. Well, thank you for being here. Albert, we're going to start with you. I believe yours is one of the communications that triggered this need for a work session. So.
Good morning, everybody. Albert Sardinas. Many of you might know.
Can you move that closer to the mic so we can hear you?
Hello? Okay. Sorry, excuse me. Good morning, Senators. Thank you so much, Chair Kuder, for having me here this morning. Many of you might be familiar with our firm, FMS Global Strategies, and some of the work that we've done in the housing space. But this morning, I am here before you as a private citizen to discuss the problems that we have faced with our own housing situation. We rent currently in Issaquah in a series of townhomes, and in the shuffle that occurred from one housing management, property management company to the next last year, just the sequence of events that have been lost in communication has been rather abhorrent. Aside from absurd rent increases totaling over 70% that we then had to negotiate as if I was trying to purchase a car just to stay in my home, of particular just poor conduct has been the matter of our utility billing, which used to be included in the rent at a flat rate, but when the new property management company took over, was removed from that flat rate, and we were then billed on a per-use rate regarding the entire townhome property, right, and all of the residents that were there. So even though several months we were not home because we were traveling, we were still billed for higher usage rates that occurred throughout the entirety of the property. Water, sewer, trash. We understand typically how trash is billed, right? If I need to get an extra pickup, I get billed extra for that. But I don't have a personal trash can. We have a area where that's assigned for everybody's garbage there. So if there's empty units, who's paying for that trash rate? Well, all of the people that are in there have to pay an increased rate because it's trash, right? It's not accounting for the fact that there are empty units, because it should just be a flat rate for the people that are in that area, right, that are in that series of townhomes. Additionally, they did a poor job describing what is a counted occupant. Is my adult son a counted occupant that goes towards our entire occupancy amount of 3 people, and we're billed for 3 people, but my neighbor that has multiple young children, who we all know kids love to leave the water running because we all did it as kids at some point, are those children who are not formally listed on the rental agreement being counted as occupants? Or am I just having to pay for what other people do? So just the totality of what we've been dealing with regards to, in particular, our utility billing has been a mess, and it's what prompted us to reach out to the Honorable Chair and to bring this matter to your attention. Thank you.
Thank you. We have a question from Senator Wilson.
Thank you, Madam Chairman, and thank you for the discussion of this. If I followed along, in reference to your personal experience to the townhouse, do you track in any way, say, regulatory compliance expenses that facility goes through? For example, property tax increases. Is there some way that you have followed that on behalf of what the property is subject to for property taxation during this time?
No, that is not something that I have followed.
Thank you.
Senator Fortunato has a question.
Thank you, Madam Chair. I know my daughter's condo, they get a yearly report, and they say, okay, there's so many units, so many square feet. your portion of all of the trash, all of the water, all of the sewer is based on your square footage of your unit. In her case, it's 0.97%. So whatever that yearly thing is, she's paying 0.97% if she's there or not. Doesn't matter how many people are in the house. Are you getting some kind of yearly estimate? Do you get something yearly, or is this just some arbitrary? Is it yearly, or is it just some arbitrary thing, I guess is the question.
It has felt entirely arbitrary and capricious. It just occurred, so mind you, there is no yearly look back, but I would presume that the previous management company would have been able to hand off what a yearly, usage would have been. But in my attempts to get that type of information from the current property management company, they've had no answer for me.
All right, thank you.
Senator Frame has a question.
Thank you, Madam Chair. So, Albert, again, if I was tracking too, so you were in a rental situation, had a lease, the property management company changed, and the property management company that took over had a change in policy of how they bill utilities and all of that. Were you under a lease at that time? Was there any change to your lease, or that billing piece just happened separate and apart with the change of the property management company?
We were still in our lease. What occurred to finish out the lease that we had at the time was a reduction in rent, because in preparation for this change to occur. And thank you so much for your question, Senator Frame, because one of the most egregious components of this is that by the time they finally sorted all of this out and sent us out those bills that were due for the period that they wanted to start tracking the rent, it was the end of December, and I got a bill for $1,600 for multiple months worth of them not knowing how to figure out what they wanted to do with the utility billing, and being told I had 15 days to pay it before I got a late fee, which, hey, okay, maybe I can do that. Right? Maybe I can take that hit. But this is not just about me. This is about the other people that live, in the units next door to me, below me, to my left and to my right. And these are families with young children. We got a pastor on one side of us, we got hardworking tradesmen on the other side of us. Not everybody can just take these hits, that come out of the sky.
So, Albert, was there a change in management that went along with this, or was it the same management company and a change in how they were providing services?
It was the change to the new management company where they just completely overhauled everything.
And how much notice were you giving of a change in management?
Same day that it took effect. It was, hey, we're the new management company. We're now overseeing. There was no prior notice.
Okay, thank you. Do we have any other questions? All right, Sarah.
Good morning. I have a PowerPoint along with mine. I'm not sure how that works.
Staff should be able to assist with that.
All right, thank you. Good morning, Chair Kuderer, members of the committee. For the record, my name is Sarah Nagy. I'm a staff attorney with Columbia Legal Services. We're a civil legal aid organization working on behalf of low-income communities statewide. And I'm here to speak to you today about repair charges that are levied against tenant security deposits, and about how lack of transparency in those charges is leading to instability for renters, inflated or falsified charges against their deposits, and driving up the costs of renting, which is especially damaging right now when rents are so precipitously on the rise. Next slide, please. Thank you. I want to give just a little bit of background about how the Residential Landlord-Tenant Act separates fees and deposits, because it specifically defines both of them separately. A non-refundable fee has to be specified in the lease agreement, and it can't be treated as a refundable deposit. A deposit, on the other hand, is obviously refundable. In addition to that, it has to be kept in a separate trust account by the landlord, can't be commingled with the landlord's personal funds. The tenant has to be informed where that money is held at all times. If property management changes hands, for example, the tenant and the trust account changes hands, the tenant has to be informed. And in the case of the landlord, declaring bankruptcy or similar, the tenant's right to the deposit comes ahead of all other creditors. The point there is that the RLTA makes clear that a deposit is, for the whole duration of the tenancy, the tenant's money. The landlord is its custodian and has to justify any deduction from it. So how does the landlord justify a deduction? There's a few requirements. The rental agreement has to be in writing and include the conditions under which the deposit can be withheld. At the beginning of the tenancy, the landlord has to provide a written checklist describing the condition of the premises. And at the end of the tenancy, the landlord can only charge for damage that's greater than wear resulting from ordinary use of the premises. And the landlord has to provide a full and specific statement of the basis for keeping the deposit within 21 days. And if any of those are missing, then the tenant has the right to up to twice the full deposit back in court, plus costs and fees, unless the landlord shows they were prevented from fulfilling these requirements by circumstances outside their control. But there are weaknesses in this law that mean that tenants often don't get their deposits back, or more and more commonly, they're charged significantly in excess of the deposit. And that's because of a sort of inherent lack of transparency in the process. For example, where resulting from ordinary use of the premises is not defined in the statute. The full and specific basis for withholding the deposit is also fairly vague. It doesn't require documentation of actual costs. It's much more common to see an itemized list that does not contain any receipt or invoice backing up the charged amount. And the landlord retains the right to send the tenant to collections, report the debt to a tenant screening agency or a future landlord, whether or not those charges are substantiated by receipts or other documentation. And that lack of transparency leads to unfair charges that tenants really have no way to contest. It's quite common to see landlords charging all tenants in a multifamily building for a standard cleaning or unit turnover, regardless of the condition of the unit at move out, basically charging the same fee against every single deposit, regardless of the individual circumstances. It's common to see charges for ordinary wear, like a sort of catch-all charge for light bulbs and drip pans, and even changing the locks, standard unit maintenance. It's common to see grossly exaggerated charges for supplies or labor with no substantiation. In the past year, I have seen the total was close to $20,000. The tenant was on the hook for a full remodel, and just one of these itemized lists with no receipt was a charge of almost $1,000 just for repainting a closet and reattaching the closet rod. So the lack of transparency leads to greater costs for the tenant. The landlord holds all of the information in this transaction, and it's difficult if actual costs are not documented and provided to the tenant to prove that charges are exaggerated, and uncontested charges become debt. That debt is a huge financial hit at the precarious point between tenancies. Move-in costs are high. Again, rent is going up, and tenants are often paying first and last month and deposit on a new place. A deposit that has been illegally withheld can't be put towards those move-in costs and raises the chances of either not being able to get into a new place or eviction once they're in if they have some other financial hiccup in the first few months of tenancy. A landlord can reject a rental application because of debt to a previous landlord, which keeps people out of future housing. If it goes so far as a collections lawsuit, it damages credit and reduces wages through garnishment. So greater transparency in fees and deposits keeps people out of debt and in stable housing. The RLTA makes clear the deposit is the tenant's money and landlords have to justify their use of it, but weaknesses in the law mean it's too easy to charge tenants for costs they aren't responsible for, which drives up their housing costs and puts them in a more precarious place for future tenancies. Thanks very much for listening, and I'm happy to answer any questions.
Senator Wilson has a question.
Thank you, Madam Chair, and thank you for the informative presentation. Just a simple question, if you know it. Do you know the number of rental units out there that are under a non-refundable fee versus a deposit structure?
No, but usually, there's a mix of them. A landlord may, as long as it's all in the lease agreement, the landlord might charge a non-refundable cleaning fee and also a security deposit. There may be a fee that's tacked on every month for having a pet, or there may be a refundable pet deposit. You know, it just depends on what the landlord specifies in the lease, and there can be a combination of both in any given rental agreement. It's just that, you know, they are treated separately in the law.
Do you have a follow-up? Okay. All right, any other questions? Okay, just hang tight, Sarah, there might be after we listen to Scott. Welcome, Scott, and please begin.
Thank you, Madam Chair, members of the committee. My name is Scott Crane. I'm an attorney at Northwest Justice Project, and thank you for inviting Northwest Justice Project to speak to this work session. NJP is the state's largest provider of civil legal services for low-income people. And last year, we spoke to over 6,000 households whose primary reason for calling us was a concern about their housing, usually an eviction or a foreclosure from their home. But in 10% of those cases, or just around 630 households, called us primarily because they did not get their deposit back or because they were contesting charges that occurred during the term of the lease. That number doesn't sound large, but it's the maximum capacity of calls we could take. So I have no doubt if we doubled our intake next year, we'd get 1,200 calls. It's an interesting issue that comes up a lot of the time that many, many people experience that we speak to every day. In addition to those calls, we talk to folks in evictions and other housing-related issues who also express concerns. So it's a very prevalent issue that we deal with quite a lot. I want to speak a little bit more, though, to tenancy fees that occur before the tenancy and during the tenancy, because we've also experienced questions from our clients in regard to those kinds of fees, and they've really developed and changed over the last 10 years, I'd like to say. At the beginning of a tenancy, there will always be an application fee. There can be holding fees or administrative fees for processing the tenancy. Many of these are upfront charges that, in addition to first month's rent and a deposit, the tenant is required to bring to the table. During the tenancy, there can be a proliferation of fees that are not related to rent or utilities for the use of the dwelling. We will see service of notice fees. If a landlord has to serve some kind of a notice on a tenant, there might be a charge associated with that on their tenant ledger. Utility billing fees, for example, if the landlord uses a third-party utility service, there might be a fee tacked on. And we're talking about fees that are $5 to $10 perhaps. One particular area that has changed dramatically is month-to-month fees. At the end of a tenancy, if the tenancy is to renew and the tenant does not want to enter into a term or a one-year lease, the landlord says, if you want a month-to-month fee, we're going to add a month-to-month. If you want a month-to-month tenancy, we're going to add a month-to-month fee, which used to be the case that might be an extra $100 of rent per month, but lately we've been seeing month-to-month fees in excess of $300, $400, $500 per month for the privilege of being able to go month to month. And so that's been a pretty dramatic change that tenants have to decide, do they want to commit to that rental for a year or two versus 6 months or whatever the case may be. Electronic portal fees, the use of paying rent on an electronic portal. The legislature addressed this issue partially last year by requiring a landlord to accept rent via check or cashier's check or money order and not be forced to pay online. But if you do pay online, there might be a service fee associated with that. We've also seen in multifamily dwellings building-wide pest remediation fees, where the landlord can't quite figure out which tenant may have caused a pest problem and distributes the cost equally amongst tenants for remediating that pest issue, which again it's a landlord duty in a multifamily dwelling to do that, and a cost that can't be borne by all of the tenants together. After the tenancy, as Sarah noted, there can be thousands of dollars in charges related to damages to the unit that might be normal wear and tear or might be more than normal wear and tear. Certainly there can be both, but because of the lack of clarity in the law around what is wear and tear and what is not, tenants often end up with $1,000 to $3,000 in fees for carpet replacement, drip pan replacement, light bulb replacement, battery replacement for smoke detectors. That all adds up to be quite a large fee at the end of the day. And as Sarah mentioned, and I want to emphasize, the difficulty we have when somebody comes to us is if they want to clear up that credit, we have to file a lawsuit, and it's a lot of work for us, it's a lot of work for the tenant, and it's expensive for everybody. It's not an ideal way to solve a problem about what is rightfully owed, but it lives with the tenant for 7 years if it doesn't get fixed, and can harm their ability to rent future housing, and often does. Finally, I'll just close by noting that the Consumer Financial Protection Bureau last year opened a docket on rulemaking looking into the increase in rental fees and heard from over 50,000 consumers talking about their experience. I would definitely encourage the committee members and your staff to look at the information that they have gathered in terms of those experiences and the experiences of folks around the country dealing with these types of fees. Thank you.
Thank you, Scott. Senator Frame has a question.
Thank you, Madam Chair. So, Scott, forgive me, I'm new to the RLTA specifically, but are fees just outside of the Residential Landlord-Tenant Act? I mean, it sounds like people are signing leases, they think they understand what it is, and then there's all these fees being tacked on that's outside of that agreement, or am I misunderstanding what you're saying?
No, so a recurring periodic fee, a fee that's charged every month, is now defined as rent. The legislature passed a bill about 3 years ago that made any periodic fee, so utilities, something that happens every month, is bundled into the term rent. There are the one-time fees, is more what I'm talking about here, with the exception of the month-to-month fee, you know, the service of notice fees, the e-portal fees, building-wide pest, those fees are all largely unregulated by the Residential Landlord-Tenant Act insofar as they are charged. And the landlord, you know, you will typically, those will be noted in a rental agreement, but if you've read a rental agreement lately, they can be in excess of 40 pages, and it's not clear to a consumer reading that they might have an additional $100 of fees in the next year associated with their tenancy.
Follow-up, Madam Chair? Madam Chair, is it okay if I ask a follow-up?
Yes,
Yes.
of course.
So if I'm understanding, the pest example is just so striking to me. Because I think in a normal, somebody who's a longtime renter, I would assume that if somebody owns a property and there's a pest problem, that's part of their cost of owning that property and running this as a rental business. If there was some problem like that that was not anticipated in the lease, the renter had no visibility on it. But what I hear you saying is something like that's happening, and they're just saying, this is no longer part of my maintenance of my property. They're converting that to a fee and passing on the cost to the renters, and it's not regulated in any way.
Well, it's regulated in the sense that that would be illegal, but what's a renter going to do about it? Go to an eviction court or be sued? I mean, again, that gets to the problem of how do you fairly adjudicate these fees without everybody having to file lawsuits and go to court? There's no way to do it. You know, there are examples where a landlord can say, yeah, that tenant is piling garbage outside their door. I'm sure the mice infestation started there, and charge that tenant. But I think more and more in multifamily dwellings, it's hard to know, and the fee is spread across the building, which is not legal, but again, what's a tenant going to do? Challenge it.
So I think that just begs the question, you know, how widespread is this practice? And, you know, I know you two have been practicing for quite some time in this area. I mean, have you seen an increase in this, or can you give us sort of some gauge on the scope of the issue?
I mean, I would say certainly for larger corporate landlords, the proliferation of types of fees is recent. The $3 service of notice fee, the $7 utility billing fee, the eviction resolution fee, and again, it comes with the very long leases that have things buried in them that have very many fees associated with it. So I think that practice is quite new. The pest remediation examples as well, that's something we're more and more commonly seeing. I can't put a number on those, but again, given the numbers we have of people who call us strictly about damages issues just seeming to be limitless, those are all bundled in that as well.
Thank you. Senator Gildon had a question.
Thank you, Madam Chair. Specifically regarding the month-to-month tenancy, it seemed like that you were kind of speaking negatively about it or saying that owners, property providers are charging these exorbitant rates, but this is a transaction between two parties, right? This is, the tenant is asking for flexibility to be able to vacate the property at an earlier rate, and the property provider is accepting risk of having a vacancy in their property and losing revenue. So this is basically this is a contract entered into by two consenting parties. And if the tenant didn't want the the rent to go up, then they would accept staying in the property for a little bit longer. So I guess my question to you is, what's the problem with that?
Thank you, Senator. I agree. It's an economic transaction out of which both parties get some benefit. The problem for the renter now, and again, as opposed to the past, is the amount of that month-to-month fee is unaffordable. And so their choice is then to move at the end of the tenancy, and as we know, there's nowhere to go. I think it's the size of the fee that has changed. Certainly, it used to be the case that an extra $100 a month, given that the tenancy might end in 3 months, is a reasonable estimation of the landlord's liquidated damages from turning over the unit. But it's when it's $300, $400, $500 that it's unsustainable for the tenant. And again, we experience problems with that with folks who are itinerant, who need to move, folks in the military who may be, again, they have rights under the Service Member Civil Relief Act. But again, these are things that people have to take into account. And if the choice is, I got to move or I got to pay $300, $400, $500 more, oftentimes they end up in that situation where they pay a lot more. So it's the size of the fee, Senator, but I generally agree with your premise.
All right, thank you. And we have one more question, and then we're going to move to our final panelist. Go ahead, Senator Wilson.
Thank you, Madam Chair. I'll be brief. Thank you for the presentation. I am a landlord, and I must say before I get to the question, I do and always want to keep my units rented. Good landlords with good renters is always a victory. You mentioned that there was a $300 example that tenants that would go to a month-to-month or wish to continue on a month-to-month. And I needed you to clarify that it was a $300 one-time fee. You said could be as high as $300. In your experience, is that a fee or is that $300 for every other month that that person that they had an agreement with would continue on? Is that a rent increase or a fee at that point?
So thank you, Senator. What's offered to the tenant is here's a one-year lease and the rent is $1,000 a month and you have to agree to stay for 1 year. If you want to go month to month, it's $1,300 a month. So it's a monthly fee. It's offered as a fee. It is rent, to answer your question.
All right, thank you. And our last speaker is Terry Anderson, Spokane and Policy Director for the Tenants Union of Washington State. Welcome, Terry. Good to see you, and please begin.
Yeah, thank you. Thank you, Senator Cooter, and thank you, members of the Senate Housing Committee. The Tenants Union of Washington State is, I think, the only statewide organization that serves tenants throughout the state of Washington. We have a statewide tenant hotline, and we have like 5 tenant educator operators that answer calls every day. So we talk to tenants every day. And deposits and fees are one of the most commonly reasons tenants call our office. But I do want to start, because we're talking about fees here too. I received an email just yesterday as I was preparing my notes for this from a small nonprofit organization in Spokane that assists some of the other nonprofit service providers in paying for move-in costs. And this small nonprofit told me that they were asked to pay a move-in cost of a $500 administrative fee. That was on top of first and last month's rent and on top of the damage deposit. And the question to me was, what is an administrative fee? Well, I don't really know what that particular administrative fee is for, but that kind of explains a little bit about the confusion that tenants get when they get these kinds of things, where a service provider has to reach out because they're not even clear what a $500 administrative fee, which obviously means it's not a deposit, it's not returnable, then they will not get it refunded. But that's in addition to all the other move-in costs. We're also seeing a very steep increase in deposits in Spokane and all over the state. Like I say, we talk to tenants everywhere. But I was just in a meeting with Spokane Housing Authority, property, and they reported that they are now increasingly seeing damage deposits of $6,000. Now, $6,000 in Spokane for a tenant to pay for a damage deposit really is prohibitive, and it really does end up making housing impossible for many people with low incomes. But again, the most common call we get are these unclear and not understandable fees and damages that are claimed on their damage deposit. So when a tenant pays their damage deposit, they fully expect that it will be returned. Now, many tenants have 2 jobs, have a family, and are really busy, and will call us and say, I knew that I didn't get to the refrigerator, but I cleaned everything else up, but I didn't think they would take the entire damage deposit just because I didn't defrost the freezer of my refrigerator, but that's what we're seeing happen. Or tenants that didn't change the light bulbs, and then when they expect to get their damage deposit check, they find that they were charged $80 to change a light bulb. We are increasingly just giving common sense advice to tenants, like rent a carpet cleaner from Safeway to clean your carpet, because if you leave any soil on your carpet, then all likelihood you are going to get a professional service charge that will entirely wipe out your entire damage deposit. And not only will you not get your damage deposit back, you will be presented with an invoice to pay the difference of the cost. So we just recently were working with a tenant who, in his own job, it was his profession. He worked for a professional cleaning company that cleaned apartments for many of these property management companies. So when he moved, he had coworkers to help him, and his job let him use the equipment. So he completely professionally cleaned his apartment, yet he did not get his damage deposit back because they said that the apartment wasn't cleaned. I think the most recent call that we're now working with a tenant who, in their lease, it says that when they move out, they have to hire a professional cleaner to do the cleaning. So in December, when the tenant moved out, they hired a company, they cleaned it, they had a walkthrough with the landlord. It was completely acceptable. And then later on, now we're in January, and just a week ago, the landlord contacted the tenant and is now questioning whether or not the company they hired was actually a professional cleaning company, and is now withholding the deposit because they don't believe that the company she engaged for the cleaning services was actually what they considered a professional cleaning company. We get calls in Spokane from Fairchild Air Force Base, from airmen who obviously are not Washington is not their home state, so they don't know the laws of the state of Washington. And I've gotten calls where airmen were told that in the state of Washington, we have a law that carpets have to be replaced in all rental units every 3 years, and the tenants have to pay for that. And when that happens with those airmen, if they don't pay the deposit, that comes out of a fund. So we taxpayers are actually paying that difference. So these unclear, and this is really where we see a lot of it, like when I go into buildings to do a workshop, if I'm talking to in a building where maybe there's many other languages spoken other than English, I find that really is a common occurrence among tenants, that English is not their first language, because they don't understand a lot of these charges. They're not written in the language that they understand. They see a number at the bottom of the invoice, they think they're going to get something back, and of course they're very disappointed. They depend on that. When tenants don't get those deposits back, they have to borrow money. They count on those because they're usually moving in somewhere else that was also creating an expense in their lives, and so they'll resort to payday loans. They'll borrow from family members. They get themselves deeper and deeper in debt, and it causes barriers for housing in the future. Many tenants don't know that debt has been assigned to them. They didn't get a damage deposit back. They're busy. They have a lot in their life. They're not going to go to small claims court to try to recover. And they just figure, I'm just glad I'm out of that situation. And then they go to move somewhere. They pay these application fees numerous times because we have such a low vacancy rate. Tenants can't just count on one rental application. And then have them all denied, finding out they're being denied in the screening because there's debt owed to a previous landlord that they didn't even know about. And now all of those applications that they submitted for new housing is just a waste of money that they can, that they had to spend in order to try to seek housing that causes a real crisis in many people's lives. And so, and we've seen a lot of these increased kind of hidden fees or increased damage deposits since the pandemic. And even during the pandemic, we saw fees increasing, tenants getting notices that no longer was storage included in the rent, that there's an additional $50 fee to store their belongings, which are already in a storage unit. So if they don't want to pay the $50, there's a burden of removing it and taking it somewhere else. I've had tenants call us, the same thing happened. They're renting a single family home with the garage attached, and somewhere down the line, the landlord says, oh, we're going to charge you $60 to use that garage. Well, they've been storing things in the garage. They park in the garage. Now the landlord puts a padlock on the garage and forces the tenants to move their belongings out of it. These are just things that we hear kind of on a common basis. And I could go on, but I don't have enough time to tell you all of our
thank you. No, it's been very helpful. I will say, just to your point about the cleaning fees, I don't know that Washington is the only place where that has happened, because my daughter lives in another state, and when she moved out of her apartment, we had a conversation ahead of time. She also hired a professional cleaning crew to come in, and I told her to take photographs. She got a $1,500 bill. And I said, write back and tell them you have photographs of the unit. And she did, and they said, oh, they made a mistake. And they withdrew it. So, I think this is an issue. I don't know how widespread it is, but it's clearly not just in Washington. Anyway, thank you. Do we have any questions for Terry? All right, thank you. Thanks to the panel. This was really very helpful and enlightening, and I think we have more conversations to have. Thank you. Okay, we're going to move in.